liberties. Article 163, sub-article 3A, the exclusive original jurisdiction to hear and determine disputes relating to the elections to the office of the president arising under Article 140. It's important to linger on every of those words. The exclusive jurisdiction is limited to elections, number one, arising under Article 140. And there's a reason it's worded this way. And here's the reason. Now, not every election is a presidential election. Now, under the definitions set out under the Elections Act, the Elections Act is itself a statute promulgated by Parliament under the provisions of Article 82 of the Constitution of Kenya. It recognizes only 3 types of presidential elections and the mechanism for it under Article 138. That then leads to a petition to the Supreme Court of Kenya under Article 140. There is then another election under Article 139, sub-article 1B. You will find this in the definitions of the Elections Act. And the third presidential election understood is Article 146, sub-article 2B. A replacement of a deputy president under Article 149 is not an election. And I must confess that Article 149 was perhaps not very elegantly, because what Article 149 does is that Article 149 almost seems to have ended prematurely, because it says within 14 days after a vacancy in the office of the deputy president arises, the president shall nominate a person to fill the vacancy. So it's a nomination. The word used there first is nominate. A person to fill the vacancy, and the National Assembly shall vote on the nomination within 60 days after receiving it. He doesn't say anything after that. But one of the things I found when I examined another statute with similar provisions, this is section 32D of the County Governments Act. Section 32D of the County Governments Act is actually a lot broader. It explains how that vote will be conducted, the time period for it, the threshold for that vote. It's a lot more elaborate. But one of the things it makes clear is that the vote akin to Article 149 is an approval. It's not an election. It's an approval. And if one were to examine the Constitution further, everywhere the word election is used, and just by way of a few examples under the Constitution, Article 86, Article 87, Article 83, all of those articles, including the powers and functions of the IBC, which my learned friend Mr. Debo will speak to later, all of those make it clear that the election contemplated is a contested election with voters under Article 1. 14 million Kenyans. That is what the Constitution understands as an election. That then invites the jurisdiction of the Supreme Court of Kenya under Article 140. So it cannot be that the respondents get to make 2 opposing arguments. They argue that because this is the argument, this is an election, so you can only go to the Supreme Court. But they argue this is not an election that requires the IBC. That's one of the things about it. Because an election requires the IBC, as properly understood. So either that argument that the Supreme Court of Kenya is the only one that has a repository of jurisdiction to determine this matter, does not find any basis, does not find any grounding in the Constitution of Kenya. You can also look at Article 106(2)(a) for what they discuss when they talk about an election. So Article 149(1) does not envisage any contest. The president nominates one name. And while I'm here, let me deal with an elephant that my learned colleagues will be throwing at you. It's actually more of a monster. In response to what we're telling you, they will tell you there is a public crisis of monumental proportions, not seen since the late Daniel Arap Moi that he will appoint a vice president if it increases the years of Ugali in our house. We will told this is the worst thing that has ever. These are vacancy. Answer number one. Article 148 does not, no, not on 148, sorry, I believe I'm talking about the sequencing where the Speaker of the National Assembly is the third in command, so to speak, when there's a vacancy. I have been waiting for my good friend Mr. Milimani, who represents the Speaker, to shoot up to his feet and protest loudly that his client is not a vacancy. Because the Constitution says, when this is Article 146, sub-article 2b. President, in an election to the office of the president, shall be held 60 days after the vacancy arose in the office of the president. Two things to bear. In that article, the framers of the Constitution contemplated a vacuum in both the presidency and the deputy presidency. It is at this point where my good friend Mr. Milimani says his client and Atosha. Maybe you say it. I am almost certain in the event that my good friend Mr. Kamoto described here a few days ago, when he said the president might go to where people don't come back, that we will not say return approach. My Lord, I never said that. The record says. Yeah, but we understood it. He was not wishing. So that's the first thing. The second thing, my Lord, is that they contemplated we can operate for 60 days, 2 months, without either a president or a deputy president. The world will not collapse. Kenyans made adequate arrangements for the caretaker, where those two are not with us. And there seems to be something magical about these 60 days that Kenyans clearly had. Because under Article 149(1), when the deputy president is impeached or there is incapacity, the president has 14 days to nominate a candidate to the National Assembly. That is number one. And because it is not obvious, or it is not a matter of course, that the National Assembly will approve that candidate, it must be contemplated that the National Assembly can refuse to vote for that. So those 14 days can be repeated, which is what the Constitution says. If Parliament rejects the first candidate, the process is repeated again. And the Constitution seems to contemplate can be repeated almost indefinitely until the President comes up with a name that is acceptable. So that is number one. And there's no crisis. The world will not end as Parliament rejects those candidates. So that's number one. But the President having nominated a candidate, the National Assembly itself has then another 60 days. So we can again operate as a country for 60 days without a deputy president. And so I return to what the Supreme Court said in the Sonko case we must do and has not been done, has not been afforded to our client, the deputy president. This is what the court says. This is the Supreme Court again at Article 114. And it's interesting because what had happened in the Sonko case, the court actually found that Sonko was not properly enforced. But they then said they converted the proceedings into an advisory opinion. So they're actually giving these a template for courts, such as this honorable court. Article 114, paragraph 114. Forward in the removal of the appellant. The Audi Alteram Patem rule requires that those who are likely to be directly affected by the outcome of a decision should be given prior notification of the action. So they give a whole list of what must be done. Prior notification of the action proposed to be taken, of the time and place of any hearing that is to be conducted, and of the charge or case they will be called upon to meet. They must be given an opportunity to be heard. Now, it is not a matter in dispute that on the night the Senate, I and my colleagues on both sides were present in the Senate. Our client was taken ill. I have subsequently read in the newspapers he had a broken heart for good reason. So he is taken ill, and the Senate then takes a vote. And this was important because the Senate had 2 days left, even in their own self-prescribed time limits. They voted, and this was not an electronic vote. They voted on acclamation to reject a motion to extend time for the deputy president to appear in court.
If I may, I am compelled to allow learned counsel is misleading the court when on affidavit. It is clear that the Senate votes electronically. The Senate does not vote by acclamation. I do not know what paragraph is addressing himself. Perhaps you can point to the court. The paragraph is addressing himself to on the question of acclamation. You can't just sit back and watch the Sharia.
I was personally there, senior counsel Muto was there, the entire team of them were there. On the question of extension of time, it was by acclamation. All the ayes and all the noes, that's what it was.
And the senator was loud.
I would ask you to please wait. It'll be a bit more bothered when I finish with this section, so it can be bothered free when I finish. So this is what the court says. They must be given an opportunity to be heard, to call witnesses, to be represented by counsel, to be availed adequate time and facilities to prepare, and if the accusations are proved, to be given the reasons. This is important. The Supreme Court says you must be given reasons for your decision. There are no reasons. They voted on grounds submitted to them by the National Assembly. They did not give reasons for that decision. Of course, beyond that, they are also entitled to challenge the decision again. You'll be told these decisions are not challengeable. The Supreme Court says the accused must have a right to challenge the decision, if against them, before a higher court tribunal. At paragraph 115, Article 47 of the Constitution enshrines the right of every person to fair administrative action. The manner of actualization of those rights have been enacted in the Fair Administrative Actions Act. Now, when this honorable court retires to its role, I would invite you, with tremendous respect, to pay attention to sections 4 and 5 of the Fair Administrative Action Act. They're important in more regards than one. Senior Counsel Paul Mite has alluded to the question of public participation, and so will some of my colleagues who will come after me. When the National Assembly conducted what it called public participation, it did not avail to the public the response by the Deputy President. What they did is prepare a charge sheet, a copy of which we'll find as Annexure 8 of our affidavit in support of the petition, which for ease of reference is at page 498. That charge sheet asks 3 questions. It first sets out the 10 grounds that the motion promoter had set out, and then asks people, do you agree that the Deputy President should be impeached on these grounds? Do you not agree? Then there was a third one, other. That was it. They were not told what his response was, nor was it given an opportunity prior to this process. Because the only way, and you'll find that this is one of the things the Supreme Court says under the Article 47, the Fair Administrative Action Act. The participants in this public participation must know both sides of the story to make an informed decision as the people who voted in this matter. The court then goes on at paragraph 116. In the process of removal of a county governor, and for this case, the Deputy President, the right to fair administrative action under Article 47, and the right to fair hearing under Article 50 of the Constitution, all accrue, and I'm paraphrasing here, to the Deputy President before a decision to remove him or her from office is reached. An unfair removal is one which goes against the principles of natural justice, just like I've demonstrated. That no adequate notice was given, that there was bias, and where the hearing was not fair. In our amended petition, which you will see in the fullness of time, we have given particulars of how each and every of these issues was violated. The Senate and the National Assembly, first and foremost, constricted the time allowed by the Constitution for themselves. They cut their own time short, and so no one had sufficient time to do anything. We have said they introduced new evidence as the trial was going. There was panel beating as the matter was going on, and as I've said, there was a lack of fair hearing. Though this is Supreme Court, though a political process, impeachment is sanctioned by the Constitution and the law and is not a platform to settle political cause. This speaks to what's in a council forum we just said a few minutes ago. It's not an issue of ticking boxes, going into a room and saying 300 of us have said you're a bad man, you must go. You're a bad woman, you must go. You must comply with each and every of the provisions of the Constitution. Bearing in mind that the removal architecture in the Constitution, the law, and the standing orders are designed to achieve accountability, political governance, and personal responsibility, and are not aimed necessarily to find criminal responsibility. On the question of natural justice, this is what, this was a decision by, I believe, your brother, Justice Odunga. It's in our list. This is miscellaneous civil application number 266 of 2017. He cites at paragraph 69 a case, I believe, from Uganda. It is a cardinal rule of natural justice that no one should be condemned unheard. Natural justice is not a creature of human. They are asking you to take away a creature, and then maybe prove what it says. It was ordained by the divine hand of the Lord God. What God has given us, do not allow this response to take away from it. And that any law that contravenes or offends against any of the rules of natural justice is null and void and of no effect. The rule, as captured in the Latin phrase audi alteram partem, literally translates into hear the parties in turn, and has been appropriately paraphrased as do not condemn anyone unheard. That is what the Senate did to the Deputy President. You cannot allow their resolution to stand. There is a decision, I will not read this for you, but this is a decision of the High Court, a three-judge bench, Republic versus National Land Commission. I believe this is miscellaneous application number 266 of 2017 at paragraph 109. The decision of the Supreme Court of Kenya in Speaker of the National Assembly versus Attorney General and three others, where the court again restated the Supreme Court, your jurisdiction in these circumstances. And then to the Senate proceedings I've just read out for you. In the Martin Wambora case, this is what this is the case. This is it's cited in the Mike Sonko case versus clerk of the Nairobi County Assembly at paragraph 226. I believe this is the High Court decision. This is what the court said about what my good friend Professor Ogenda was getting a bit more under the collar over. Although it does not fall within our remit to direct the legislature on how to perform its functions, we are of the considered view that impeachment of a governor is a serious undertaking, just like a deputy president, as the end result can lead to the removal of a popularly elected governor. The deputy president before you and the president who ran for election in 2022 were elected by a vote of slightly over 7 million people in this country, out of 14 million people who participated. It's a very serious matter. For this reason, we recommend that it will be desirable that future impeachments proceed through the committee route as opposed to the plenary. This is what the court is saying. We say so because when the special committee is appointed, it has 10 days to deliberate on the matter, thus giving ample opportunity to the parties to adequately prepare their cases. The Senate chose not to avail itself of this constitutional mechanism. The committee gives the perception that each member is actually engaged in the process as opposed to the plenary. the trial of the deputy president was held entirely in plenary. And a lot of things, when you look at the Hansard, for example, there was a lot of issues raised about a succession matter that has nothing to do with the constitution. Okay, when you look at the Hansard, a lot of things that have nothing to do with this constitution, and here's the problem: the committee gives the perception that each member is actually engaged in the process as opposed to the plenary, which can be perceived to be a mob lynching process, which is exactly what happened. That is our submission before you. It is what my late member of parliament from Kangema, the late John Joseph Kamodo, used to call Kura ya Makelele. Now, is apprehended cannot be undone. Once is apprehended cannot be undone once it happens, or cannot be undone without undue hardship or expense, or cannot be adequately compensated by an award damages. The court takes into account the respective that grant or refusal of relief is likely to fraud the party. I want you to take my colleagues' submissions where they say you cannot undo once a new candidate for deputy president is nominated and sworn in. They say the court has no jurisdiction to undo that appointment. This is what they're telling you. You cannot undo a deputy presidential nominee who has taken office. This is what they're telling you. At any length, they tell you it is a political question. Don't even look at it. That's where they began. Don't even look at this. The president knew what he was doing. Take him at his word and his actions. So that's one side of the balance of the scale. On the other, you have a sitting deputy president who is before a court of law, as he ought to be. If in the unlikely event his petition were to fail, all he does is go back home and we swear in the new once the petition is dismissed. But conversely, if you swear in a new deputy president, you kick in motion a whole series of events, including a president, deputy president, who is now exercising constitutional mandate, who is chairing cabinet committees, that may ultimately be found to have acted outside the constitution of Kenya. The balance lies in granting conservatory orders so that we can do this in a civil manner. What former Supreme Court judge of the Supreme Court of Kenya, Justice Joan, used to call a pacific resolution of the dispute. As I say, the Constitution has given ample time for all of us to interrogate these questions. 60 days is the magic figure the Constitution gave us. Let's not be in a rush to undo the timelines given to us by the Constitution. And finally, the decision, I believe, Gachagua'S, the question of the public funds that are expended, swearing in a new deputy president, getting him a whole fleet of cars and workers, trucking power, and as the custom, perhaps even doing the road to his village, all these sort of things. So let's hold our hands until we can determine whether the process that led us to this day was done constitutionally. That is the Peter Gachagua'S decision. My lords and your ladyship, the decision you make in this matter will echo in eternity. Being a constitutional democracy or a democracy. I beseech you, do not let us go down the path of autocracy and dictatorship. Thank you for the privilege of attending this. Start fast, followed by this. Start fast, followed by this. And then this correct purposes of presenting application. Well, let me start by thanking the court for the decisions that it rendered on the last Friday on the questions of direction that it gave for the hearing of the petitions that have before the court. But I confirm that the process of amending the various petitions is ongoing and will be filed in accordance with the timelines fixed by the court. Well, going by the timelines that you gave, it is also my pleasure and appreciation, and that is in
ensuring with the compliance with the rules that it is possible for your law to ensure that in the same way that the month of October we deal with the political aspects, with the political phases of impeachment, that it is now possible, courtesy of your direction, to ensure that we can be able to have a judgment on merits for purposes of the various petitions that are before you. That will be an absolutely important issue for this court to remember, because it is being made as if it will not give in due process and ensuring substantive hearing of this matter, that we shall be here until forever. And all these businesses can actually be concluded within the month of November. That being the case, my lord, by way of introduction, let me say two things in my own words as counsel representing, I believe, the 4th to 8th petitioners who filed the application that is before the court.
The date of your application.
Yes, my lord, that is exactly the issue. 18th, my lord. The application was filed on the 18th of October. My lord, 18th, it is supported by an affidavit sworn by Honorable David Milimani on the same date. My lord, for purposes of the document, let me start there. We have filed submissions. The submissions were filed yesterday. There is a supplementary we filed today, and we have filed various responses to the affidavits to set aside that my learned colleague, Mr. Ogata, will be referring to them. My lord, that being the case, I wanted to say that by way of an introduction, there are two broad issues that I can be able to say. My lord, thank you. My lord, the first issue is that the petitioners moved the court moved the court in Gachagua'S in view of the fact that under Article 3.2 of the Constitution, every citizen of Kenya has an obligation to defend and protect the constitutions of Kenya. That's a broad mandate. And of course, further to the other mandate, that under the Bill of Rights, from Articles 19 to 23, where the Bill of Rights is being violated, they are permitted to come to this honorable court to seek for the appropriate reliefs. And therefore, that is the basis upon which they came and have moved this honorable court. My lord, the second broad issue that I wish to cover at this particular stage is to point out basically the big thing about the matters that are before you. My lord, the big issue for purposes of the matters that are before you is that these impeachment proceedings, after you hear us, two possible scenarios are clear. Number one, the deputy president who has already argued his application, as his advocates have pointed out, is an elected deputy president, an election that was conducted on the 9th of August, 2022. My lord, on account of the vote of impeachment passed by the Senate on the 17th of August, 2024, if the process concludes in accordance to the manner in which it has so far been implemented under Article 149(1) of the Constitution, it would result into Kenya having an appointed president 2 years after one who is elected was put into office. My lord, that's a big thing, whichever way you look at it, for the simple reason that one of the important devices of the 2010 Constitution was to ensure that the holders of the offices of president and deputy president have the direct mandate of the people. So, in a matter where that important issue of our constitutions will change, it is our submission that every absolute care must be taken to ensure that the process and the law leading to this very critical political and legal transformation on our constitution has been addressed. How will this be addressed? My Lord, we shall be arguing together with my learned colleagues that the only way in which this can be done is through the hearing on the merits of the petition that are before this court. My Lord, having given those introductory remarks, let me come to the application of the 18th of that day, and by highlighting the issue that we both clearly know. My Lord, impeachment, and many cases, I will not go through them. The many cases that have been cited of impeachment shows that impeachment in Kenya has four processes. One, where allegations are made, that is purely political. Muduse went around, collected his evidence, presented. There was a motion, I believe, dated 29th of September, asking Parliament to have this 26th, I'm told 26th of September. That's the stage one of the political process. Stage two of the political process is the stage where the National Assembly approves by a vote of 2/3 of all the members to allow or to reject the impeachment motion. My Lord, that was done. There are various issues that have been raised in the majority of the petitions that will be argued in the fullness of time that shows the significant problems when this matter was at the parliamentary level. Topmost of them being the impartiality of the Speaker and the Deputy, together with the manner in which public participation was handled. Stage three, my Lord, is a stage of the Senate. The law clearly talks about what the Senate should do, how the voting should be done, and again, there is evidence. My learned colleague, Mr. Ongoya, and Honorable Muche, we pointed out the significant problems that we had there. I am most interested, my Lord, in the fourth phase. The fourth phase of impeachment, as it has now been established in our jurisprudence, is where this court seeks to establish whether there was compliance with substantive law and procedural law by the political organs upon which the mandate of impeachment has been entrusted upon by the Constitution, other laws, and the respective standing orders. Again, my Lord, that phase that where the court is supposed to deal with this issue, it is our submission that this is the stage that this honorable court must ensure, because it is the court that all aspects and proceedings are dealt with in a manner that you are hard, and I'm happy for the time that the court has agreed to allocate us, so that the court with sober minds can be able to decide have the laws of our country been upheld or not. My Lord, there are clear guidelines that have been set out by our constitutions for purposes of doing that. And my Lord, because we are here because of an application for conservatory orders, under Article 159 of the Constitution, this court has an express duty that in exercising the delegated judicial power of the people of Kenya, it is required, the certain guidelines have been given by the Constitution and Article 159, that is besides other provisions of the Constitution. And one of the most important ones is that the court will do substantive justice. Substantive justice is an important issue, and it has specific meaning through the very many decisions that have been rendered over time by the courts of this country. And the clear meaning in plain English, because it is important we understood in plain English, In plain English, it means a very simple thing. That, for example, my lord, if we have a case of a goat, Mr. X and Mr. Y have a case of a goat, this goat should remain alive and should so that at the end of the decision, the court can decide whether it belongs to Mr. X or Mr. Y. That is the very simple meaning of substantive justice. So that, my lord, substantive justice, therefore, conservatory orders, is a mechanism that our laws preserves the good. Our laws preserves the subject matter of the case. The subject matter of the case, my lord, is the questions of vacancy in the office of the president. Going by the Senate, the deputy president was impeached. On account of the orders that have been given, that office is yet to be filled. So that, my lord, the question, therefore, is easy to define and can be defined this way. That, as we wait for the hearing and determinations of this case, it cannot be settled at the interim level that the Honorable Kindiki will now be the Deputy President of Kenya, so that as we argue the petitions, there is already the impeachment process has been concluded to the disadvantage of the other people, of the other person who is seeking the same office. So that, my lord, is a simple issue that is very easy to define. So that, my lord, we shall be arguing that when we come to that particular issue, why on earth, because you have before you, because if a conservatory order is a legal mechanism, the legal device that is established by the Constitution to preserve the substratum of the matter, and for this court to do substantive justice, how on earth does the respondents expect that substantive justice will be possible if the trophy that is being tussled over, that is being contested over, is handed over to them? My lord, all systems of justice would be offended to be told that it is possible at halftime for one team to be declared to be the winner before the matches is concluded. Why can't we wait for all these issues to be concluded? It is a simple meaning of what substantive justice is all about. And the court, the duties of the court to ensure that the ring is held even for all the parties, so that we do not argue over an academic matter, which should be the worst issues that can happen. But there is the case of the Gachagua'S Peter Munya. I'm coming to the application for conservatory order on them as quickly as I'm able to. And the Gachagua'S Munya and other decisions, we have a big authorities, many authorities. Their issues were set out very, very clearly. There are three tests. The first test is on the prima facie case. But my learned colleagues have set out the various many legal issues that are there. That from the standpoint of the applications that we are arguing before you, there are 5 issues for purposes of prima facie case to comply with the Gachagua'S Munya case. The first one, my lord, is public participation. I don't need to go into that. It's a substantive issue in the majority of that issue. My lord, the second issue is what we call the legality of the standing orders of the Senate. My lord, in the petition filed in Gachagua'S as 015, the petitioners, amongst other things, are saying that although the Constitution provided for clear timelines on how, for example, the business is going to be conducted, and specifically saying that this investigative committee is the only committee that can be able to discharge that constitutional function, the Senate established standing orders under which the plenary of the Senate can also resolve that issue. The Constitution of Kenya does not provide for a mechanism on how the Senate can discharge that function, but it is very clear on how that investigative committee is supposed to conduct its business, and how the right to hearing is to be given after a finding has been made that there is a case worth responding to. But what I submit, that's a big issue on the standing orders that were used to pass the vote of impeachment. The second issue that has been sought in that case is the issue of interpretation and application of those laws on impeachment, 44, all those laws, 48, 144, 144, 149, all those have been raised. My Lord, as you clearly knows, this is a first impeachment for purposes of those laws. And therefore, if a question of interpretation has been raised specifically before you, it underscores the necessity to ensure that on merits, this court actually determines and interprets the law, so that the next time we have probably to plead against the president or against the DP if he gets there, the law will be clear and we shall not be going through all these things. So a serious issue has been raised by that petition. The other serious issues that have been raised is, of course, the fairness of the Senate proceedings. I will not go into that because already the lawyers for the Deputy President have raised that issue. And the fifth important issue is the issues of nominations of the Honorable Kindiki. That issues of the nominations, my learned colleagues will say more about that. But as we wait for their turn to come, the only two issues that I need to say at this early stage is to point out the fact that that under the Constitution, I believe Article 137 of the Constitution, any person occupying the office of the Deputy President or the office of the President must be qualified in accordance with the constitutions of Kenya. Under the impeachment articles of the Constitution, these issues of the constitutions on the qualifications are not set out. So that because they are not set out, it is an assumption that when reading the Constitution holistically, this court will go to those other specific provisions of the Constitution where the issues of qualifications are set out. My Lord, those issues of qualifications are many. One, and the body under the Constitution, my learned colleague Mr. Nego will say more about it, is that ABC confirms whether any person has those qualifications or not. I don't think that is a contested issue. I believe it is also not a contested issue that at the time that the President of Kenya appears to have received some letter from IEBC confirming that the Honorable Kindiki is duly qualified to hold the positions of President, of Deputy President, courtesy of Article 149 of the Constitution, we do not have IEBC. Of course, various arguments can be taken by the parties that are involved. Those arguments cannot be concluded. Those arguments cannot be arguments to justify whether or not you will settle when the petition has been had. The second important issue on the aspect of the nomination of Kindiki that I need to point out is this, that even assuming the president did the right thing and everything else that he was doing, this court should be concerned by the fact that whilst the case was still going on before the Senate, the National Assembly scheduled a meeting by the National Assembly, which under Article 149 has 60 days, a meeting to occur the following day, within about 7 hours after the vote of the Senate. Why should this concern the court? It should concern the court for the simple reason that under Articles 10 and 118 of the Constitution, Parliament cannot pass a law or make important decisions like approval of the Honorable Kindiki without engaging in public participation. The cases are so many for me to cite them. The jurisprudence is so clear for it to be disputed. So that, my Lord, the argument that we shall be putting on the issue of the nominations, on the face of it, unless this honorable court is able to say that at this stage, that public participation does not apply to the nomination and approval by parliament, then, my lord, it is clear that this is the kind of case in which you are dutiful to confirm the conservatory orders until this petition is heard and determined. Because the precondition would have to say, we have excluded this process from public participation. You would have to resolve the main issue, one of the main issues, at this stage before the petition has been heard. That would obviously be irregular. Now, none of us expect it to happen. I still wonder how the respondents would expect for them to get such kind of an order. I go to the second test. For whether those of this is not a difficult argument. I had a little bit say something about it. But my lord, the whole argument would be this, that if the whole argument, and that has been our case since we first came here last Tuesday, that we cannot, my lord, be able to have a situation in which the petitioners are saying the constitutions of Kenya has been systematically violated, and that all these conservatory orders that are in place are meant to complete the constitution. Your first duty is to defend the constitution. That duty is particularly greater for the simple reason it was when Medu, is it called Medu? The LP that one. When the mover of the motion had that duty under the constitution, conducting, making appointment at 149, National Assembly had that duty. But my lord, you are saying in those 5 instances, the constitution by individuals, state officers who are under a duty to uphold the constitution, then the duty of this court to ensure that we do not turn this constitution into a mere platitude, into a hollow document, a false prospectus, is all the more greater. And it is for those reasons, my lord, that I would be saying that everything would become negatory when they can be able to say mission accomplished. They can go one day after the ruling. They can go to Uhuru Park or whichever other place for them to say we are swearing in victory. That would be a mockery of justice. But there is a greater mockery of justice that I want to point out. Because this thing, and to break it down for the people, every order in the normal litigations we do with every day, and you say somebody's rights are going to be violated. If somebody is saying I should not be hanged, I was not convicted properly by the High Court, if, my lord, that person is hanged because before he has been hanged by the clearly, it would mean that the process of justice has not been completed, yet we have hanged them. But not in America. They keep on hanging people. Many of them terrible criminals, mass killers. But my lord, you will observe that at the time when we see these televised killings in America, it is always after they have exhausted judicial process, so that they are sure that process that are irreversible take place after every legal benefit and protection has been afforded. One of those that is important, my lord, is captured under Article 27 of the Constitution, the right to protection of law. So that the issue, as long as I'm in court, the matter is not yet over. It might well be possible that we might lose this application, the interim application that is before the court. But we might also win it, and we are likely to win it. So that, my lord, of that issue, that a person may actually succeed at the other stage, is the reason why you prevent taking irreversible decisions. And my lord, what is the scenario that we are talking here? My lord, the scenario here we are talking about here is simple. Immediately after assuming the orders were lifted, that's the scenario I want to describe. What is it that is going to happen? My lord, we would have a scenario where the Chief Justice, whilst these proceedings are pending before the court, would have to preside over the swearing in of honorable
Why don't we put in order to keep speculating about this very issue?
My lord, the issue of swearing
And
in is
also, and then it's referred to 3 times now, this is the 4th time.
my lord, I believe that's the law. They have been saying what?
And my lord, whereas you are not,
Then,
I was to ask my lord, what is the dispute before you? Is it the impeachment and whether it was lawful, or is it the nomination of the second interest?
First of all, it's both, and I would want some proof so that we are all fair. They will have to respond and not interfere with each other. But so that the important scenario that we must seek to avoid is a situation, and this is matter. It is also a matter both of the constitution and statute. My lord, by your brother judges. So that, my lord, the issue, as far as we are concerned, that is an absolutely important issue. We go to the next important issue, public interest. My lord, public interest has been defined in very many cases that are before you. And my lord, these public interest issues are just supposed to ensure that in administering justice, the court will do the right thing. Because we actually have a transformative, one of the best courts in the world, for the simple reason that we wanted to be a good example across the world as a leading constitutional democracy. The issues of public interest is placed at the heart of our constitutional order. I go, my lord, to the definition. This is the only long passage that I will be reading. And this is, I gave the supplementary authorities earlier. This is in the famous case of Murugaro, Christopher Darabi Murugaro versus Kenya Anti-Corruption. This citing the passage appearing at page 7 to 8. My learned senior, Gedi Muigai, will be familiar with this decision. My lord, from the last paragraph, what did the Court of Appeal say on public interest? I read, it says as follows. Lastly, before we leave the matter, Professor Muigai told us that the strongest point on the motion before us is a public interest. We understood him to be saying that the Kenyan public is very impatient with the fact that cases involving corruption or economic crimes hardly go on in the courts because of applications like the one we are dealing with. Our short answer to Professor Muigai is this. We recognize and are all aware of the fact that the public has a legitimate interest in seeing that a crime of whatever nature is detected, prosecuted, and adequately punished. Expect to be involved in corruption and economic crimes and simply lock them without much ado. That is not the path Kenya has taken. It has opted for the rule of law, and the rule of law implies due process. Must stick to that path, even if the public stick to that path, even if the public may in any particular the Court of Appeal, the Supreme Court, they can only do that on the basis that they are sitting in an appeal on a decision already made by the High Court. So that, my lord, it will be the submission that this reinforces the huge burden that this court must undertake. And my lord, the final issue that was being understood here is to say a constitutional democracy would not mean anything unless due process is upheld. And due process is the first duty of the High Court to ensure that in whatever dispute that is before the court, before it is decided, the court has confirmed due process has been observed and as a constitutional democracy. That is a standard, because they could try to compare ourselves with a dictatorship. That as a constitutional democracy, we can live with the decision. As my learned colleague Mr. Ngoya was saying, we cannot possibly live with a decision in which we will be seeing the Chief Justice, if that were seeing the Chief Justice swearing on the committee, where we are arguing this matter before the court. So that the rules are clear, the rules do not require much elaboration on what they mean. And since that criterion of public interest has been met by the Supreme Court itself, my Lord, I urge you to uphold it in a manner that will best ensure that the constitutions of Kenya and its dignity have been upheld. My Lord, there is the question, so that I believe that we are very clear on public interest, except to emphasize that for the specifics of this case, what does the call of public interest require this court to do? It's a simple call, 5 quick things. Number one, to confirm that the law on impeachment has been properly interpreted and applied. That's the first issue. To confirm that the law on impeachment has been properly interpreted and applied. Number two is to achieve substantive justice for the parties, so that when a judgment will be issued by this court, at least everybody can win something, that nobody goes home with a whole of victory. That is the whole idea of substantive justice. The third issue is to determine that the issues of the violations of the constitutions is done while the matter is still alive before the court. My Lord, very serious issues on Articles 27, 38, and 50 of the Constitution have been raised. They are all under the Bill of Rights. We urge that while public interest needs to be upheld by ensuring that when this court pronounces itself in a judgment, those issues would not have been turned into a heading. Number four, my Lord, is to ensure that the integrity of the presidential or political succession that is written in express law under our constitution is not rendered ridiculous or ineffective. And in those, I point out what we had said earlier, the desire of the makers of the constitution was any person who will hold the office of deputy president and therefore can potentially become president without an election ought himself to be an elected official. So that it's a big thing. If this office, and without good reason, to accept political rules, is held by an appointed person. It is in public interest that an elected deputy president, except for the clearest of evidence, except for the greatest of sins that are clear to all men of justice, is not removed from office. Now, the fifth issue is to do this. Now, this court protects the constitution. I already talked something about it, so I don't have to go much into it. But there are only two decisions, if I sit down, that I would like to point myself to. There is the issues of Gelongori versus Attorney General, which is one of the cases that are before you. The facts in Gelongori are notorious, and they are also notorious for the simple reason that that decision, those old advocates who are there, upon which Dr. Gibson Kamaukuya tells us, that it was largely, though it was a three-judge bench, it was written in the style of Chief Justice Madan. But that issue says something that is important to me, the young advocates in Kenya. And what it said is this: it emphasized the question of justice. And it emphasized the question of justice with the simplest meaning in plain English. You need to ensure everybody has a fair and square deal. This is to say that at the end of the day, everybody will leave the court and say, probably my advocate was not as good as I thought, but the judge did their best. But at the end of the day, let it be very clear that the court did everything that is possible to ensure that justice in its substantive form is achieved. This decision was rendered in 1984, long before the article on 159 was written, and that is why it is celebrated. And my Lord, it is also celebrated, and I am mentioning here for that reason. whenever honorable men, candidates before the Judicial Service Commission are called upon to name whose jurisprudence has affected them, it is Justice Madan that is mentioned very many times. I will strive to be like Justice Madan. And my lord, it is for good reason. All of us celebrate Justice Madan because he's trying to do justice. But my lord, in the same case, the older lawyers also told us about Alan Hancock, about Dagdale, and even about children. They tell us all these things. But my lord, in those interviews, I do not hear anybody saying I want to be like Alan Hancock. So that my lord, I cite Madan in order to support the proposition that Judge Madan would never remove the conservatory orders that are before him. And the principles of doing justice and offering everybody a fair and square deal. The last case that I want to cite before I hand over to my learned colleague, Professor Ogata, has he told you? Oh, I thought when he has disappeared. But before I hand over to my learned colleague, is to point out to one little issue.
The petitioners, you have exhausted 2.5 hours. Budget how we are going to.
Yes, sir. Yes, my lord, we are budgeting. Yes.
No more than 30 minutes.
Yes,
And
but
you
my
could
lord, I
always-
understand.
you could try-
Yes, yes, we try to do
You
our best.
have no more than 30 minutes.
Thank you, we will do our best. My lord, for purposes of this case, it is the only thing I'm citing before I go. This decision, like you've had very many other decisions on constituent power and everything, this will be an international decision. It's a decision that will be read by universities across the country. And therefore, the least that I can do is to confirm that the lawyers for the petition are still familiarize themselves, as Macharia tried to do, with what other courts internationally have said. There is a small issue that I want to address myself to. My lord, in 1928, in the case of Olmsted versus United States, one of the most celebrated justices of the U.S. Supreme Court, Justice Brandeis, says as follows. This is important. Our government is the potent, the omnipresent teacher. For good or for ill, each day. As being a process that ended up being a government project, contrary to what was clearly spelled out by our laws. And my lord, it becomes something that all laws were broken, and virtually out of the constitutions. I was counting them yesterday. It looks at 30 provisions of our constitutions have been seriously violated in the manner that this process has been undertaken. Then we have a situations that Justice Brandeis had in mind when he talked about the government, which should be the lead in upholding the law, ends up being the principal breaker of the law, the principal violator of the Constitution. It is within your hands, Your Lordship, and Your Lordship, to ensure that does not become our scenario. My Lord, Macharia, my colleague, emphasized something, but I want to finish by adding something. My Lord, in June 1982, when Kenya was legislated into saying that Kenya is a single party state and KANU is the only legitimate organ, this was through a long process. Honorable Rengo, Honorable of June 1982. We must hold and ensure the events of October 2024 remains regrettable and an aberration on Kenya's constitutional order. Not, my Lord, I am thankful for the time. And I look forward to this.
Thank you. How many people are left to speak?
For these applications, there are two. I was with Mr. Gada and Mr. Bekwa. They have heard you when you talked about that minutes. They will try to divide the time amongst themselves.
The court must always remain the conscience of society. That is the spirit of the Constitution 2010, and that spirit has been reiterated time and again by this court. Mine is two tasks before this court today. I will be going through a panoramic vista of the authorities before this court. And finally, I will go through the political question doctrine, something that has quite excited the other side, and to debunk the myth that the political question doctrine in any way applies in the context of the Constitution 2010. We are dealing here with an application for the preservation of conservatory bodies, and insofar as the application in petition E15 is concerned, in terms of prayer B and E, extension of those conservatory bodies to cover the entirety of the proceedings pending judgment and determination. My senior colleagues have gone through the essence and the reasons why conservatory bodies ought to be granted. Mine is just to buttress this. That I will add this court to look at the decision in David D. and others. That was a 5-judge bench decision led by Professor Justice Joel Budi, as he was then. And in paragraph 29 of their ruling, that is dated 26th February 2024, and in that decision, quoting a decision from the Supreme Court of Appeal in Nigeria, in Siemens Company versus Dangote Industries, the court says that conservatory orders are prophylactic. They are intended to save the subtracting of petitions. And as been ably demonstrated by my colleagues before me, we will sit at monumental oddity, the perfect storm in the teacup, when we allow certain processes to happen, including the swearing in of Professor Kindiki, who argued with me the BBI decision. Legal distillation, what would mean by an legal distillation, what would mean by an arguable case, and in terms of that infamous term that was bandied here before, the term nugatory, it has been judicially defined. You look at what the Court of Appeal in Kanyade, Ndui, and Ole define nugatory to be. In terms of public interest, we will invite these honorable courts to look at the case of Ethics and Anti-Corruption Commission versus Professor Domogenda and Associates and others, whereby the Supreme Court says that an additional link to be examined is public interest. And we have labored in our submissions, Lordship, the presiding judge, to itemize 7 items of why the Constitution, as was articulated by my learned senior lawyer, why the Constitution qualifies as the highest embodiment of public interest. We are here to argue for a conservatory order to issue as a prophylactic device to save the Constitution. That's our constant movement. It should not be forgotten. Still on the question of public interest, my friends representing the first petitioner have in their bundle of authorities 2 cases. Court of Appeal decision in Matini versus the Attorney General, 2023 EKLR, the CAS case, famously called. And then we have the Ojo case, Ojo versus Agriculture and Food Authority and 8 others, 2024. I am reliably told that that was argued by my good friend, Professor Tomogenda, my senator, Queen's Calling alumni. And in that case, this is what the court said, in a nutshell, that we need to keep out a nominee from public office so to protect the Constitution, the integrity of the Constitution. Keep out the nominee. Let them not go into office. That is what we have been arguing. Ojo, Matindi, CS, Oh, I have it CS, by the way. Elisha Committee. Not just this new bugger, an authority that we have supplied in case of Willis and Joyce 2016. This is the two 2018 appeal cases we provided that. One new bugger says this, that so far as the High Court is concerned, Queen judges are not technically bound by the decisions of their peers, but they should generally follow a decision of a court of coordinate jurisdiction unless there is a powerful reason for not doing so. That creates an honest deciding judge, Mrs. Milimani, Mrs. Mugambi. Now the other side has to satisfy you that those courts, including yourself, made an error in making those determinations for you to depart from the same. Elisha Ngoya painted a beautiful picture of how odd that would be. We have also provided the case from the Supreme Court of the Parliamentary Service Commission. This is Martin Nyanga. Court there examined decision making and vacation of the same in the context of a collegiate court. The test has been given there by the Supreme Court. And what the Supreme Court says is that if this court might be tempted to reverse what has been made in terms of decision by a collegiate court, then the error has to be substantial. It has to be demonstrated. It does not simply amount to a question of mere allegation, perfect and perfect. It has to be shown demonstrably the satisfaction of this court. I want to move quickly to the question of political question. My good friend, my brother, Mr. Gumbo, has spent a lot of ink, black and white, submitting on this, and he's submitted to this court the authority of Baker versus Carr. To him and those on that side who submit in that line of thinking, we say this, that the political question is an American constitutional emanation, and this was done by no other than His Eminent Grace, the Lord Justice Mrema, in the case of Anthony Miano and others, to the Attorney General 2020 E.K. Lara. Thirdly, the political question focuses on limitation by courts on the court restraining itself from dealing with matters within the responsibility of the political arms of government. Now, in terms of the US context, and I have said that Mr. Gumbo has submitted on this case, and we wish to respond to him. This is what they did not tell you in terms of Baker versus Carr. Baker versus Carr 1962 lays down 6 factors that can be used in identifying what a political question is. So the political question within the American context is not a general rule of application. It is applicable, yes, but within certain parameters. And the context in which that political doctrine question principle can be used, number one, there is lack of a judicially discoverable and manageable standards for resolving the dispute. In other words, the judiciary does not have the wherewithal to deal with that question. Number two, the impossibility of deciding the dispute without being to the detriment of a political policy determination that has been made. Number three, the impossibility of the court undertaking such independent resolution without expressing a lack of respect to the branches of government, the political branches. Number four, the unusual need for unquestioning adherence to political decisions already made. Number five, the potential embarrassment from multifarious pronouncement radically different from the American. From the text of our Constitution, this is what the Court of Appeal in the BBI decision said at paragraph 139 and at paragraph 144. At paragraph 139, the Court of Appeal said that the Superior Court, being this court, Article 22.1, 23.1, and 258.1 of the Constitution, had jurisdiction to complete